Hi, my name is Brian Rath. I am a member of the Board of Trustees at IDF. I am a longtime volunteer at IDF, and I am also a PI patient. In addition to all of that, I am an attorney, and I'm here to talk to you about what are your rights with regard to employment and your PI. I have to start off by saying, as all lawyers do, anything that I say here cannot be constituted as legal advice. I'm here just to talk to you about what the law is and what your rights may be. If you have any specific concerns, you may have to talk to a lawyer on your own, but I'm certainly here to give you a brief overview of the laws that impact us when we are employed, and hopefully to be able to answer some of your questions. The two main laws that are going to impact PI patients when it comes to employment are the Americans with Disabilities Act, the ADA, and the Family Medical Leave Act, FMLA. Now we look at the ADA is what provides us protections. It provides any disabled person protections, allowing them to continue to work and to work in the workforce. And the Family Medical Leave Act provides protections to disabled people, like people with PI, when they need to take leave due to their disability. It guarantees the continuation of the job. It protects the job, and protects the health benefits and things of that nature when people take leave for disability. We can start off with the ADA. And the ADA, it's important to know that under the law, it says that no covered entity can discriminate against a qualified individual on the basis of their disability. And when we talk about who is a covered entity under the Americans with Disabilities Act, essentially it's any employer that has more than 15 employees. So pretty much all employers are covered entities under the ADA, and employers really need to provide reasonable accommodations for people with disabilities who are qualified to do a job so that they can continue to do the job despite their disability. What is it? Who is a person with a disability, and what is a disability? Under the law, the definition of a disability is pretty expansive. It's any physical or mental impairment that substantially limits a major life activity. And you can see on the slide, there are a number of different things that are labeled as major life activities that a disability can impact. Each case is looked at individually as to the disability of an individual employee and the impact of that individual's disability upon their life activity. But one thing that has been decided under the law is that a PI is a disability under the ADA. So there really doesn't need to be any type of analysis as to whether or not a person with documented PI is disabled or not. That's pretty much already been established under the law. A disability under the ADA can be temporary. It can be something that someone is experiencing. Maybe it's just a temporary illness or something of that nature. It doesn't have to be something like a PI that will follow us around for the rest of our lives. It's also important to note that the disability is not just for someone that has a physical disability that's obvious. A person who has a record of a disability, the record of that disability is sufficient to qualify because we as people with PI far too often hear things like, well, you don't look sick, or you don't look like there's anything wrong with you. Well, you know what, we may look great. Certainly every one of us that has a PI looks great all the time. But the fact that we have a PI, it's documented, we live with it, does qualify us for disability protection under the ADA. What is a reasonable accommodation? That's the question. What does an employer have to do to reasonably accommodate an employee under the ADA? A reasonable accommodation is pretty much a modification or adjustment to the job or to a policy that allows that individual with a disability who is qualified to do the job to participate equally in the workforce. And types of reasonable accommodations include things like even just putting in a ramp for someone with a wheelchair. Something as sort of simple and obvious as that allows that person who is in a wheelchair but can still certainly perform the job that they have been hired to do. It's an accommodation allowing them to continue to work. Other reasonable accommodations can be things like a modified work schedule, allowing someone to adjust their hours. For someone like us with a PI, a reasonable accommodation could even be just giving some time off for infusions or treatment or doctor's appointments or something of that nature. That's certainly can be seen as a reasonable accommodation. Breaks during the day, maybe more breaks than are necessarily put in policy at an employer. Adding breaks for someone with a PI or some other kind of disability can certainly be a reasonable accommodation. The real limit on what is a reasonable accommodation is it should not be something that creates an undue hardship for the employer. So when we talk about accommodations, that's the limit, and that's something that needs to be looked at by the employer on an individual basis. What constitutes an undue hardship? The nature and cost of the accommodation. How much is this going to cost the employer? If it's not a reasonable expense, then maybe it isn't. Maybe it is an undue hardship. What are the overall financial resources of the facility or of the employer? Certainly, an employer like Apple would have much more financial resources to accommodate its employees than perhaps the small business mom and pop pizza shop down the street. So certainly that's a factor to weigh. Maybe the same accommodation that someone needs can be certainly afforded by a large corporation much better than it can be afforded by a small solo-owned proprietorship or a small mom and pop store. And so that's another thing that needs to be taken into account. What type of operation does the employer have? What is the job? Certainly, some accommodations cannot be made, to accommodate a disability. If the employer's job is driving trucks and someone is blind, they can't drive a truck, and there's no accommodation that can, that can assist that employee in making in performing that job. And quite honestly, that employee isn't a qualified employee to perform that job. And what is the impact of the accommodation on the operation of the employer? So that's another question, because what is a person's right, our right as a person with a disability to a reasonable accommodation does not mean that we get to pick and choose what that accommodation is. So we may not get the accommodation we think is appropriate, but if it's a reasonable accommodation from the employer, that's all that they're required to do. And if it impacts operation, that can be a concern. If there is a job that requires attendance, and there is no way to make it a job that can be done, electronically or to be done from home or remotely, and it does require attendance, then the reasonableness of an accommodation allowing a person to not show up for work or take extra time or take extra leave may not be. It may impact the employer if that job needs to be at the premises, maybe dealing with customers or face to face or something of that nature. So that could be an unreasonable request for accommodation based on what the operation of the employer is. So, this has been certainly, the ADA has gone through many court cases and many interpretations, and has over time the protections for disabled people and for people that certainly can perform jobs, has been really looked at and solidified. And I think for people like us with a PI, there are multiple protections under the ADA for us. What does the ADA prohibit? Well, one, it prohibits discrimination. we can't, people with disabilities and people with a PI can't be treated differently. And we can't be impacted differently. When we talk about disparate impact, an employer can't put in a policy that seems to be neutral, but really impacts someone with a disability more than it would impact other people. Policies need to, and treatment needs to be pretty much uniform across the board. The ADA prohibits an employer from failing to accommodate. The law requires an accommodation if it's reasonable and if it doesn't pose an undue hardship. An employer just can't say, well, that person has a disability, I'm not going to hire them. That person is in a wheelchair and they need a ramp, and I'm just not going to put one in. The ADA requires those accommodations. The ADA prohibits retaliation or harassment for someone with a disability who requests a reasonable accommodation. The ADA provides protections from the employer harassing or retaliating against that person, or even other employees harassing or retaliating against that person merely because they requested an accommodation. You can't get fired because you requested an accommodation. That's the ultimate retaliation. You are protected under the ADA. Important, the ADA protects people in the hiring process as well. So if you are applying for a job, particularly for someone with a PI, and most often we don't look like we have anything wrong with us, and we go into an interview, the employer cannot ask questions about our disability. The employer cannot ask, are you disabled? The employer can't ask, how often are you out of work because you're sick? The employer can't ask us information about any type of health concerns or disability. Now, certainly the employer can ask whether or not we're able to perform the job. Do we have the qualifications? Are we a qualified employee? Are we able to perform the job? And certainly, in most instances, we wouldn't be applying for the job if we were not able to perform it. But they can't ask any questions about whether or not we have a disability that might impose upon the employer some kind of accommodation or anything of that nature. So the protections are there for us from the hiring process all the way through employment. Once we're employed and we have a job, unfortunately, many people with PI are going to need or get sick. We certainly get sick, and we would like protection for the time off we would need for getting sick and for taking care of ourselves. We also need protections because many of us have children that have a PI or family members that have a PI, maybe a spouse or a parent. And what do? We have a job, they get sick, we need to take care of them. So the Family Medical Leave Act does provide protection, some protection for those of us that are impacted by a PI and need some sort of leave to take. We need to take some leave from our jobs. Now, the Medical Leave Act, the FMLA, I'm sure many of you have heard FMLA. It entitles employees to take time off from work to deal with an illness or a disability of the individual for a certain period of time. And when we take that time off of work, the employer is required to maintain our health insurance. And that really is sort of the most important factor for people with a PI that need to take time off of work. Now, it's important to note that the law does not require that time off to be paid. And so, that is something that definitely needs to be considered when we're taking time off. But, it does require that we would at least have, our health insurance, and that when we came back, we would be able to come back to a job that was the same job or something equal to the same job. So if we had to take time off and our employer had to fill the position that we were in, when we came back, we would have the right to either go back to that position, or there would have to be something else in the employer's jobs that we would be able to take that would be something comparable. Who's eligible for the FMLA protection? It doesn't start automatically when you get a job. First, it's only for employers that have more than 50 employees. Now, these 50 employees do not all have to be at the same site. They can be in various different locations, but employers covered, must have 50 or more employees. Now, and I should have said this up front, when I'm talking to you about both of these laws, I'm talking to you about the federal laws, the national laws. There are 50 different states, and 50 different states have their own interpretations of these laws. Some may be stronger, and so we would have to look at each state in which this issue would come up to see if there are any additional protections. But as far as the federal law is concerned, that's what I'm really focusing on. So employers would have to be 50 plus employees. You as an employee would have to have worked at least 12 months for that employer. Now that doesn't have to be all in a row, but you would have to have put in 12 months with that employer, and you've had to have worked at least 1,250 hours during the past 12 months. So that that covers that's certainly more than part-time, but it's less than full-time. But it does, for a full-time employee, it's a low bar, I think. And so you do have to put in time to your employer before you are qualified to take FMLA leave. What are the reasons to leave? Obviously, your own serious health condition, and that's for a lot of us with PI. I certainly have had my time that I have had to take FMLA leave in the past. But it's not just for my own serious health condition or your own serious health condition. It is to care for a spouse or son or daughter or parent with a serious health condition. So those of us that take care of people with PI, we can take this FMLA leave, for those considerations as well. There are also other qualifying reasons to take FMLA, whether certainly at the birth or adoption of a child, and there are specific FMLA requirements or protections for people that are either active duty service members or family members of active duty service members. But for our purposes, it's for our own health condition or the health condition of one of our loved ones. It's important to understand that FMLA leave it has its limitations. One, employees can take up to 12 weeks of FMLA leave, but that leave is unpaid. And that's always an important consideration. Now, those 12 weeks don't have to be taken in a row. They can be taken over time. They can be, that's 12 weeks per year. So, people will use FMLA leave for, for taking time off for procedures, taking time off for even infusions when, there are going to be, we know that there are going to be side effects for a couple, and it would be for a few days. So FMLA leave can be chopped up into little pieces, but we have a total of 12 weeks overall per year. So, that is, it's advantageous for those of us with a PI, because oftentimes we will get sick, get taken care of, get on antibiotics, be better in a week, and then have to go back to work. And, if we need to take FMLA leave, if our employer requires it, we then will have that protection. This leave, because it is unpaid, can be covered. Our pays, our salaries and our payment can be covered by PTO, can be covered by sick and vacation days. A lot of employers will require us to do that. They will require someone taking FMLA to use all their sick days, so that but the thing about that is that there will be there will be continued payment when those sick days are being used, when the PTO is being used. When FMLA runs out after 12 weeks and there is no more coverage for payment, there are other considerations that need to be taken into account. Perhaps an employer may offer short-term disability benefits. Some states offer short-term disability benefits. I'm from New Jersey. New Jersey has its own state short-term disability benefit program. So if for some reason an employee needs more than 12 weeks, there are other options out there and other options to be considered. So with all of this, and it's a quick dive into some very big laws that impact those of us with PI pretty significantly. What are some questions? And these are questions that I have had discussions with other people with PIs through IDF over the years. And how does PI impact my job search? Well, unfortunately, those of us with PI have to consider the impact on our ability to perform certain jobs. It was my personal opinion that my PI would not stop me from performing any job. I will do what I have to do to make it happen. But I have the understanding that there are limitations. So, but the question is, well, when I pick a job and I want to go in and I want to apply, how does my PI affect me? Well, as I said before, the employer in the application process, in the interview process, is not allowed to ask you about your PI, about your disability, about any health questions for that matter. They can ask you only about whether or not you can perform the job and how you would perform the job. But then if they don't ask, do you tell them? And when should you tell them? And that is a question for each one of us individually. I know when I first applied for jobs, when I was first looking for a job, I didn't tell my employer up front about my PI. In my opinion, my PI did not impact my ability to perform the job. And but I know some people that do. I know some people that are very active in IDF and in the PI community that if an employer Googled them, they would find out, a lot of public activity that these people have done with the PI community that they're very proud of, and they put it on their resume. And so they want to talk about their PI upfront in an interview, and that is certainly everyone's right. But know going into an interview or into an application process that the employer is not allowed to ask you and not allowed to make a decision based upon your PI. After you get the job, what should you do? Well, you don't have to tell even after you get the job. You don't have to disclose your PI unless and until you need an accommodation or you need some assistance. And at that point, then you would probably need to tell your employer. But you don't have to tell them up until that point. And what should you do if you're having trouble with your employer? There are many resources out there for people that are having ADA or FMLA concerns. Obviously, even just Googling it up front will provide a wealth of information and a wealth of resources. Certainly, you can contact IDF. IDF can point you in the right direction to help you with the resources you may need to get some help with your employer, because those of us with a PI, we're certainly capable of doing anything we put our minds to, and we have the right to be protected in doing that when we are looking for employment and being employed. So I thank you very much for allowing me to share this with you, and I look forward to taking your questions.
Hello, thank you so much, Brian Rath, for that presentation, and a special thank you to all of our participants for joining us for this Q&A session. My name is Ashley Ferreira, and I will be the moderator for today's Q&A. At this time, I would like to give a special thank you to Brian Rath, a member of the IDF Board of Trustees and an attorney at the law firm Buchanan, Ingersoll & Rooney in Marlton, New Jersey. I do want to give a quick disclaimer. Please remember that each individual's treatment and condition is unique. The information presented during the session is not medical advice, nor is it intended to be a substitute for medical advice, diagnosis, or treatment. Always seek the advice of a physician and other qualified health provider with questions concerning a medical condition. We've already received a number of excellent questions, so thank you for sending those in. At this time, we're going to go ahead and begin with our Q&A session. And our first question, Brian, as offices reopen and COVID restrictions and mask requirements are lifted, could the ADA be invoked to allow a patient with PI to continue working from home if that PI patient feels their health may be at risk from COVID?
Well, thank you, Ashley. Before I answer the question, I do also have to add my own disclaimer that although I am a lawyer, nothing that I say here is actual specific legal advice. This is just general discussion advice. If you do need specific legal advice, I suggest you hire your own attorney. And that is my very legal, lawyerly way of saying, you haven't hired me. But I can certainly ask and answer any of these questions. The big question is, what do we do now that we're coming out of COVID and offices are reopening? And, it's a concern for all of us. The ADA still does apply and applies to COVID. So when we, with people with PI, go back to work, our employers still are required to offer reasonable accommodations for people with disabilities. That's us. So, I recommend that people with PI are able to go to their employers and say, look, we're coming out of COVID. I have an immune issue. I need a reasonable accommodation in order to perform my job the way I should. Now, your employer is going to be required to evaluate your request and provide you that reasonable accommodation. And the test that I discussed in the presentation still applies. But we have people with PI have already a qualifying condition under the ADA. So the idea is to go to your employer and discuss reasonable accommodations. Now, as I discussed in the presentation, what your idea of a reasonable accommodation and your employer's idea of reasonable accommodation, they may not be the same. So an employer can't be forced, and the ADA does not require an employer to allow people to continue to work at home. That is an option that the employer should look at. But if there is another reasonable accommodation that they can make and they still want you to come in, that may be something that would have to be worked out. But they have that option too. So the bottom line is the ADA still protects anyone that is concerned about COVID, particularly those of us that have a qualifying condition like a PI. So we can talk about masks. There was also a question here about can I still wear a mask to work? I still wear a mask to work. I'm just now getting back into my office. I'm very fortunate that I have my own office. I can close the door, but I'm going in and out of the building and I'm still wearing a mask. A number of people in my office still wear masks. An employer cannot require you not to wear a mask. And I think that's important for you to know. Ashley, do you want to continue asking questions, or should I just go on?
I'm going to go ahead and ask this question as a follow-up. You did mention that there was people who, if they're interested in professional advice, they should look for an attorney. What type of attorney should they be looking for? Would it be a labor attorney if they want to request reasonable accommodations under the ADA? What should they be looking for?
Yes, you would want to go in your state, in your town. Looking online, it's pretty easy to find, and I would call them employment attorneys. When we talk about labor attorneys, those are the lawyers that usually represent, the companies. Unless you're in a union. If you're in a union, you should go to your union rep. But generally, if you're not in a union, you would look up employment lawyers online, find an employment lawyer that that represents employees as opposed to employers, and or even look up ADA employment lawyer online and find someone in your town. That way, those are the types of lawyers that would be able to best help you, guide you through the ADA or FMLA and how to address your concerns with your employer.
Thank you. And I know that we talked briefly about the ADA. A question that came in: does the ADA apply when an employee is harassed and or discriminated against while taking advantage of perks that accompany the job? For example, an employee of a recreation facility using the facility during non-work hours.
Absolutely. There is an anti-retaliation provision in the ADA, which is pretty strong, meaning your employer cannot take any action against you to retaliate for your exercise of your own rights. Now, retaliation is a very broad definition. And so that includes harassment, that includes discrimination, that includes differential treatment of you as an employee. That also includes these types of harassments and things like that from other employees. So your employer cannot discriminate against you or retaliate against you in any way for taking advantage of your rights. If it's other employees that you're having a problem with, then you would need to go to the employer to inform them and say, hey, look, I'm taking my reasonable accommodations. You've already given them to me. I appreciate that, but I'm getting some, concerns and some issues from the other employees. Go to your HR person if you have one at your employer and talk to them about that, because the employer is responsible for protecting you from other employees and from the harassment of other employees. So the ADA certainly protects all of us that need accommodations from any type of retaliation for taking those accommodations.
What about volunteers? Are they protected under the same rights? Do they apply to volunteer jobs?
Yes, volunteers are still protected under the ADA, not so much under FMLA. But if you need an accommodation, that is reasonable, then you can go to the employer and say, hey, this is what this is what I need.
Wonderful. What about ADA accommodations in an undergraduate, postgraduate education setting? Do those still apply?
Again, it's the same, and see this particularly regarding COVID. Yes, so especially when we're talking about schools do need to accommodate people with disabilities, and so when you're in school at a university, the best place to start is the university's disability office, and say, okay, look, I have a PI. The COVID is still out there. I need some sort of reasonable accommodation, whether it's continuing online education, if that's possible, whether it's someone to take notes for you in class, maybe some isolation where you're separate and apart from other people in the classroom now that if they're bringing people back on in person. But it's the disability offices at universities generally are pretty helpful about these types of things. Everyone's working through COVID now. Even now that we're coming out of COVID, it's still new to everybody, but they should be able to work with you. The ADA still applies, in this world of COVID.
Thank you. Our next question: should you put an FMLA on file because you have a PI, or wait until you have a sickness requiring it?
Well, this is interesting. This goes back to the FMLA does not kick in essentially until you need it. It goes back to whether or not you choose to disclose your PI to your employer, and you don't have to. There's no law, there's no requirement that says you have to tell your employer about your disability until it's necessary. And so if you're perfectly healthy and you're doing fine and you don't need any leave or anything like that, then you can just go about life like anybody else. If you were to get sick and you need FMLA to take advantage of FMLA and the leave that's offered, then that's when I would suggest, that's when you go to your employer. If you haven't already had this conversation, then you go to your employer and say, this is what I need. This is why, whatever forms the employer needs you to fill out, they'll have to, you'll have to have your doctor fill out certain forms, but there's a standard procedure for that for most employers. So you don't need to invoke FMLA until it's actually necessary. You don't need to, prep anybody for it.
Thank you. What steps should an individual take if they report a problem to their employer, but the issue is not addressed or resolved?
That's always difficult because really, the employer is required to do this, to address your issue. Now, the employer, they may do the analysis and decide that that certain accommodations they think are reasonable and you don't. The only step after exhausting all of your discussions with HR and with your employer are to consult with a lawyer. Really, you can come to IDF and we can advise you, with certain resources and things of that nature. But really, the next step is to take advantage of your rights, legally by getting advice from someone and from a lawyer that can help you. Oftentimes, it may just take a letter from a lawyer that says, hey, these are their rights. This is what we think, and the employer will take it a little more seriously. It's sad that has to happen, but sometimes that is what's necessary.
And following up to that, do you have any advice for individuals who might be worried about retaliation? For example, such as a school district, maybe they work there and they're worried about the retaliation that might follow if they seek more accommodations or file complaints.
Again, and I see this question on the chat, and the first sentence is retaliation happens though, and it does, and that is a problem. And while most employers would like to accommodate their employees, there are plenty of employers that don't. You have rights. This is coming from a public school teacher, so I assume you're also part of the union. Yes, the problem is, you can take advantage of your rights, and if you are denied those rights, your next step is to whether it's file a complaint with the EEOC or file a complaint with your union or file a complaint or look to a lawyer. That's the next step in what you can do to protect your rights. Are you going to be retaliated against because of that? It's possible. Now, that is absolutely against the law for your employer to retaliate against you for that. But then the only way to prevent that or to fight against that is to continue to fight. So we as people with PI have to fight so often when it comes to our healthcare. Unfortunately, a lot of times we find that we have to fight when it comes to employment as well. And there's only so much that we individually can do without having to bring a professional in to help us enforce these rights. That's why these laws are on the books. These laws are on the books because employers don't follow them necessarily, and because they're there, someone can help us and get them enforced.
Thank you. When it comes to time off, are there certain limits to time off, even with a disability? For example, when flu season kicks in, maybe an individual feels like it's not a good time for them to go into work. What are the time off limits?
Well, as I discussed in the presentation, which I must say in this platform that we're doing, thankfully I did not have to watch myself do the presentation again. That was good. But in the presentation, I did talk about FMLA, and the FMLA is the law that allows people with disabilities or illnesses, or taking care of others with an illness, to take time off. Now, the limit for FMLA is 12 weeks of unpaid leave. So great, this law allows us to take time off and still come back to our job or a job at a similar job at our employer after 12 weeks. But it is unpaid, which is difficult. So we can, depending on the employer, we can take advantage of sick time or paid time off and things like that to continue payment during that time. But the FMLA allows for 12 weeks of unpaid leave and protects your job. Not only does it protect your job, but importantly for us, it protects your health benefits. And so that's the limit, under the law. There is also recently, because of COVID, an emergency COVID relief, I think it's called Families First COVID Relief Act or something like that, which allows people 2 weeks of paid leave in addition to normal sick time if they have COVID or if they are taking care of someone with COVID. So that is separate and apart from FMLA. And that will last as long as we are still in this federal state of emergency with the COVID pandemic. But yeah, there are limits, unfortunately, to how much time you can take off.
Thank you. And unfortunately, these Q&A sessions are never quite long enough, so we are getting close to the end. But I would like to ask you one last question. When it comes to looking for a new job or when you're in the job market, how should an individual handle disclosing their PI? Is that done during the interview process until they're hired? What recommendations do you have there?
Well, really, it's a personal preference. There is the law actually says you do not have to tell an employer about your disability, really, unless and until you need accommodations for it. So if your PI doesn't, create an issue and you get your your infusions, or you can do your sub-Q when it does not impact your employment. You don't ever have to tell your employer. But if it does, and you maybe need time off because of infusions, or you get sick, then it's and you need accommodations, then you can tell your employer. But it is a personal preference. I did not tell my employer when I first started with the job at my law firm, and I went through the interview process and did everything. Didn't tell anyone up until a point where I needed an accommodation, and then I disclosed. I work with the teen program and the young adult program, and there's a lot of our teen council members who have been very open. They've written articles, they've been online, they've done all sorts of things related to their PI. So when they went to go be employed, somebody did a Google search on them, they would find all kinds of IDF information about them. Well, those kids, when they're doing it, they were just very open about it. So it's really a personal preference as to, and honestly, those kids said to their future employers, look, I did all this volunteer work, I do all this work with other people, this makes me a better employee. So it's really a personal preference. The law does not require you to disclose your disability until or unless you need an accommodation.
Thank you. Thank you so much, Brian. We really appreciate you being here and helping individuals become their best advocates. This is definitely an important area that many of our community members have questions about. So thank you so much for being here. We appreciate you.
No, absolutely. I'm glad to be part of this community, and glad to participate.
Thank you. For those who will be joining us for the farewell ceremony, please do make sure that you go to the auditorium for that. It has been a pleasure spending these last few days with you during our PI conference. We certainly hope that you've enjoyed many of these sessions. We hope that you will go back to view many of the recordings. They are available to you, and we look forward to seeing you at the farewell ceremony. Thank you so much, and have a wonderful day.